A federal judge confirms that Letitia James' star witness, Michael Cohen, is a liar. Now, we already knew this because he was convicted of perjury, but he lied again. And the argument is that he lied in Engoron's courtroom. Now, this is a big problem. He either lied in Engoron's courtroom or he lied in another courtroom when he was pleading guilty to the other crime. Any way you cut it, dude's a liar. And Letitia James, made him the star of her entire prosecution against Trump that resulted in $500 million judgment. Remember, it's not just me saying that it's Michael Cohen being the star witness. This came out during the trial itself, and people like ABC News were saying the same thing. Remember, this guy flipped. He was going to come and help Trump be removed from the game because he knew all the inside scoop. ABC News posted this back in 2023 October, said former fixer, now the star witness, Michael Cohen, is going to face Trump at the fraud trial. The whole thing started with him. He's the inside guy who apparently tipped off Tish, and she's been relying on him. He is the keystone, right? When the whole bridge comes together, that keystone at the top that connects the two. Without that, the whole thing crumbles. So he now has been called out in a separate case. And this is going to have some pretty, I think, serious implications for the credibility of all of these cases, because a federal judge in Michael Cohen's perjury case is now confirming that he's a liar. So let's go through that filing before we get some reaction from Cohen, Alina, Habba, Vivek, and of course, the man himself, President Trump. This is the filing in the case against Michael Cohen. So we're used to spending time in the Trump cases, but this is Michael Cohen as a defendant. So some time ago, Michael Cohen pleaded guilty, and we're going to go through what happened, but this is the US DOJ versus Michael Cohen. And what he's trying to do now is get off probation. He wants to terminate the penalty of this case because he's saying, I'm super cooperative with the government. I helped Tish. I helped her by testifying against Trump. Well, what if all that testimony was a lie? And a federal judge just said that. Here's the opinion in order. You see, this is Jesse Furman, U.S. District Judge, writing out of the Southern District of New York. He tells us some background. He says, all right, this is Cohen as a defendant. He says, we're here because defendant Cohen pleaded guilty to evading income taxes, to lying to banks and to Congress, and to violating campaign finance laws. That's why we're here. Now, on December 12, 2018, citing this veritable smorgasbord of fraudulent conduct, okay, that's a quote, not my line, I wish it was, that's pretty good. A veritable smorgasbord, I like it, of fraudulent conduct, the Honorable another judge, William Pauley, sentenced Cohen principally to 36 months in prison. Remember that, right? Back in 2018, Cohen shows up, all this fraud, lying to the banks, lying to Congress, lying on his taxes, 36 months prison, and then 3 years of supervised probation, supervised release. Now, since that time, Cohen has applied multiple times for a reduction of his sentence, each time without success. First, Cohen, soon as he was finished, in December 2019, Cohen moved for a reduction of his term in prison pursuant to the rules of criminal procedure. Now, Judge Pauley, right, a different judge, denied that motion in March 2020. What? December? You just pleaded guilty in 2018. It's been 1 year, weirdo. You're on 3 years probation. Don't come back after 1 year and say you're done. So he says, no, you're denied. Get out of here. Back on probation. Then between July 2022 and May 2023, after the case was reassigned to me because Judge Pauley died, Cohen's like, oh, perfect. Judge Pauley's dead. Perfect. Hated that guy. Didn't grant me an early termination of my release. Good riddance. Then he's like, perfect. We can file a motion now since that old man's dead. So then Cohen filed 3 motions for early termination of his term of supervised release, which is due to expire in November of this year anyway, right? He starts firing them off. Perfect. We got a new judge. Boom, boom, boom. The court denied all 3 of those. And in this opinion, the court, me, the judge, we turned to a 4th motion. We're on number 4 here for early termination of Cohen's supervised release. And the question, honestly, this judge is like, whether sanctions are warranted, because remember, Cohen cited those 3 fictional cases that don't exist to get off probation in this case. So here's the background. Now, the judge fills in the gaps for us. He says, all right, look, convicted perjurer Michael Cohen liar says the relevant background begins with the court's denial of Cohen's 3rd motion for early termination, right? So he files again. Judge is dead. This guy files another one. Now, in opposing that motion, so the DOJ, the Department of Justice, they alerted the court to the statements that Cohen had made in his recent book and all over the TV. So Cohen wrote a book called Revenge, right? And I don't know if it sold anything, but specifically Cohen, the DOJ told the court, because, okay, let's, zoom out. Court is sitting there. They're handling a bunch of other cases, right? A bunch of other stuff. This motion shows up from Michael Cohen. They're like, Cohen again? What? 3rd motion. They got to notify the government. The government says, hey, okay, judge, just want to let you know while you're considering whether to terminate him now. It's been about 2 years. Just want to let you know. He wrote a book and he's been on TV. And they tell the judge specifically, he falsely wrote in a book that he authored. He said that he did not engage in tax fraud. And that the tax charges were all 100% inaccurate. And that he was threatened by the prosecutors to plead guilty. Well, that's weird, because when you take a guilty plea, as we've talked about here before, the judge asks you that specifically. Has anybody threatened you, promised you anything in this plea to get you to do this, coerced you? Are you under the influence of drugs or alcohol? Do you speak English? Do you read and write English? Okay. No, nobody promised me anything. Are you doing this of your own free will? Yes, all the questions, yes. So if he was threatened, that was the appropriate time to say that, so that he could have brought it to the judge's attention and the judge could have addressed it. But he didn't. So he pleaded guilty, and then he says it was all fake. Weird. And the prosecutors are noting that. Now, in an attempt to distance himself from his guilty plea, where he made false statements to a financial institution about tax medallion liabilities, Cohen stated on television he showed up on MSNBC with Ari. He said, first and foremost, there was no fraud in the medallions. I don't even know what he's talking about. And he's quoting panic, Trump melting down over Cohen's arrest, or imminent arrest, right? Trump was getting arrested. So the court denied Cohen's motion. They said substantially for the reasons set forth in the government's letter. It sounds like you have no remorse at all, Michael. We're not terminating anything early for you. And singled out the statements from his book and TV. Now, these statements, the court said, when they denied him, hey, sorry, Michael, they suggest that a reduction of Cohen's supervised release would not serve the purpose of the sentencing, which is including deterrence, rehabilitation, and proportionality. So, you get a benefit by saying, I did it, I'm sorry, I made a mistake, I'm going to be better, I promise, mom's here, she's going to look over me, I'm not going to do this again. You get some leeway for that traditionally. And then when Cohen comes out and writes in his book, that was all fake, I got threatened, it's not true. Everybody goes, what? Prosecutors say, what? So they say, okay, apparently you haven't learned your lesson, so we're not going to reduce your probation, obviously. So then undeterred, Cohen, through his counsel of record, David Schwartz, this is the judge writing, by the way, filed yet another motion seeking early termination of supervised release. Now that was on November 29th, and something happened after that date, right? So David Schwartz, this guy says, okay, let's try this again, third time. In his motion, Schwartz argued that there had been a substantial change in circumstances since the last denial. Namely, guess what? Cohen testified for 2 straight days in New York versus Trump. That's Tish's case. Remember that? Cohen showed up and was the star witness, as ABC News mentioned. And he sat there and supposedly testified. Now, Schwartz asserted that Cohen had endured 2 days of grueling cross-examination, and where Engeron was basically protecting him the whole time, and that his testimony had been widely lauded and publicized, okay? So this is him basically justifying terminating his probation early because he got involved in the Tish case. It's a quid pro quo. Terminate my probation because I testified against Trump. I should get a benefit from that. Now, Cohen's, quote, willingness, wrote his lawyers, to come forward and to provide truthful accounts of his experiences, it demonstrates an exceptional level of remorse and a commitment to upholding the law that cannot be denied by this court or the U.S. Attorney General's office or the DOJ. So they said, right, he went and ratted out Trump. Now, in support of this motion, though, something weird happened, and you remember this because we talked about it. Schwartz cited and described 3 examples of decisions granting early termination. And you remember they cited these fake cases. They cited all these cases. U.S. versus Figueroa, great case, and United States versus Ortiz, and United States versus Amato. But there was only one problem, writes the judge. The cases do not exist. Now, although the government failed to point that fact out in its opposition to Cohen's motion, E. Dania Perry, who entered a notice of appearance on Cohen's behalf following the government submission, disclosed in a reply that she'd been unable to verify the citations in the Schwartz filings. And so the court looked into it. Court said, where did these fake cases come from, Cohen? On December 12th, the court entered an order to show cause. Said, you're busted, buddy. You and your lawyer get over here. And we want order to show cause in writing why you should not be sanctioned pursuant to the court rules and the inherent power of the court for citing to non-existent cases. Now, the court directed Schwartz to provide a thorough explanation of how the motion came to cite cases that do not exist and what role, if any, Michael Cohen played in drafting and reviewing the motion before it was even filed. The court reserved judgment. So then Schwartz, right, so just to zoom out on this, a motion went in on their 3rd attempt and cited fake cases that said, everyone else gets off probation. Look at these cases. Here's evidence of this. Turns out those cases didn't exist. So now Cohen's lawyer, who ultimately submitted it, got his own lawyer. So Cohen, also aided by Perry and these lawyers, they both responded, right? We read through, I think, Cohen's response. Now, with one exception discussed below, they tell about the same basic story about how these fake cases came about. In early November 2023, Schwartz, Cohen's lawyer, sent a draft of what would become the November motion to Cohen. He sends it over to Cohen. Now, Cohen asked Perry, who had not yet entered an appearance on this case yet, to provide feedback on the draft, which she did. So this is another person, Perry. Cohen has maybe another friend who's not on the case yet, or another lawyer. What do you think? Now, one comment which Cohen passed along to Schwartz was that the motion should cite a few cases that grant early termination. It's like we probably should find some cases, like maybe, is there precedent for this? Hopefully, like we should do some legal research. That might be a good idea. Good job. Good thinking, guys. So Cohen passed along to Schwartz. So apparently now it goes from Perry, right? We're playing the game of telephone, to Cohen, then from Cohen back over to Schwartz. Add some case law. Schwartz adopted what he understood to be Perry's suggestions, and he sent subsequent drafts back to Cohen. So he says, yeah, good idea. I will add some case law. Then on November 25th, Cohen gets this draft. Cohen then sent 3 emails to Schwartz with cases in question and summaries of the cases. So Cohen's like, yeah, that looks pretty good, but we need some case law. So Cohen had gotten the cases from, dun dun dun, Google Bard. Oh no, which he did not realize was a generative text service like ChatGPT. Oops. And he didn't realize that it could show citations and descriptions that looked real, but actually were not. No. Instead, he thought it was like a supercharged, super magical, super duper search engine. Yeah. That just spits out whatever you want, cases that just are made up. According to Cohen, he didn't have access to, Westlaw, which is an actual legal service, or other standard resources for confirming details of the case. And he trusted Mr. Schwartz and his team would vet those new cases before incorporating them into the motion. Now that trust, the judge says, proved to be unfounded. Although Cohen's emails made no reference to Perry, Schwartz believed that the cases had been found by Miss Perry, given the earlier back and forth. Didn't think it came from Cohen. He's like, if I would have known it came from Cohen, I never would have used him. That guy's an idiot. Because of Miss Perry's reputation, right? She's a renowned and skilled trial lawyer. And so Schwartz did not independently review the cases because she's actually a competent person. Now he notes that he never contemplated that the cases were non-existent, that their inclusion in his motion was an honest and an unfortunate mistake. He had no intention of deceiving the court. And the first he learned about this was when the court issued its order to show cause. He goes, oh no. He then spoke to Perry's colleague, who informed him that Cohen, not Perry, had been the source of the cases. Now Schwartz professes that he would have researched the cases if he knew that they came from Cohen. He's like, that guy is like dumb. So he acknowledges that he bears responsibility and the submission that the inaccuracies in it were completely unacceptable. He sincerely apologizes for not checking the cases before personally submitting them. Like, I can see that happening, right? Like that guy's, he's probably doing Cohen a favor. He's like, oh, this guy's so annoying. Just stop calling me. All right, I'll file your stupid motion for you. Files it. It should be a simple, motion to terminate probation, like very simple, not a big deal. The case is closed. Judge says no. What's the worst that can happen? Judge says yes, it's successful. It's like a very low risk motion, low risk filing, except when it's Michael Cohen's. He creates fake cases that get you called into court on an order to show cause. Now, as noted, Schwartz and Cohen, their recollections differ in one respect. We're not even at the lying stuff yet, right? This is just his incompetence. We haven't even gotten to the lies yet, which are coming. Schwartz recalls that Cohen had, before sending him the cases in November, he thinks Schwartz says that Cohen told him that the cases would be provided by Miss Perry, right? Schwartz says, look, I'm pretty sure Cohen told me they were coming from Perry. He didn't tell me they were coming from him, which was one reason that he believed the cases came from Perry, because Cohen told him that. Now, Cohen denies that he said anything of the sort to Schwartz, although he does not dispute Schwartz's claim that Schwartz mistakenly believed in good faith that the cases had come from Perry. My guess is, right, that these are just kind of friends of Cohen. Cohen is probably just trying to do this all on the cheap and trying to, have people just do him favors and not pay stuff, right? He doesn't want to get billed for all this. So he just is trying to do some research on himself. He's like, I'm a lawyer. I'm smart. I can do this. Oops. In the court's view, that discrepancy is ultimately inconsequential. Okay. I don't know if Schwartz did it, based on that or not, but at most, Cohen told Schwartz on some unspecified date that Perry would later provide cases. Schwartz does not suggest, and the record does not show, that Cohen identified Perry as the source of the problematic cases. And moreover, even if Cohen did not say anything to Schwartz to suggest that Perry would provide the cases, Perry's comments on the initial draft that Cohen forwarded to Schwartz provide a good faith basis for Schwartz's belief that Perry was the source. All right. So like, in other words, Perry was in the document. They were sending this draft back and forth. Perry was in the document. So he saw some of her comments. So he thinks she's involved. Now you see how extensive this investigation is, right? Like this judge is like really upset about this. They're breaking this down play by play. Now, all of that is to say that the court credits Schwartz's testimony, Cohen's lawyer, that he genuinely, but mistakenly, believed that the cases had come from Perry, that he did not independently review the cases based on that belief. He would have researched the cases had he known that Cohen was the source, and he did not intend to deceive the court. Too bad, gulags. Sorry, new standards. No one's above the law. Sorry. In light of the foregoing submissions, the record is complete, and two discrete issues are therefore ripe for this court's decision. First, whether Cohen's supervised release term should be terminated early, and second, whether there should be sanctions for citing the non-existent cases. The court will address each in turn. So again, we are in Cohen's criminal case, and the judge is about to blast him for lying in Tish's case, which is a separate case, but this is federal court versus state court, and we're going to see whether there are consequences that will spill out of this. So Cohen now is asking for early termination. He says, first of all, this first issue can be addressed relatively swiftly. Cohen wants to terminate this thing, and I know a court may terminate probation anytime after the expiration of 1 year if I revisit certain factors and I think it's warranted and in the interest of justice. Now, in particular, the court says if I'm considering Cohen, here are the things I'm supposed to look at. Should I terminate his probation early, his supervised release? Deterrence, public safety, rehabilitation, proportionality, and consistency. Now, significantly, we don't terminate probation and release early as a matter of course. It's actually only occasionally justified. Otherwise, it needs to be the same. It's got to be exceptionally good behavior, and that's that. Now, in light of those factors, right? So the court just gave us those factors: deterrence, public safety, rehabilitation, and so on. He says, well, I've thought about this, and Cohen's latest motion for early termination is denied. Sorry, Michael. Fourth time. Failed again. Womp, 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 womp. Cohen's principal basis for his renewed motion was his October testimony in the Trump trial. Again, right? So Cohen is saying, I deserve a benefit because I went and did this. Now, that is motivation for him. He can only testify if he has something to say, and he needs to testify whether or not he has the truth to say, so that he can use that as justification to get his probation terminated early. He is playing this game with Tish so he can take the benefits of that game and get off probation and get a benefit. That makes his other testimony lacking in credibility because he has an improper motive to do it. Now, as the government notes, however, that testimony, okay, so he says, I helped Tish go get Trump, look. But the DOJ is responding and they say, actually, Judge, that testimony in and of itself is why you should deny his motion and not grant it. That testimony itself is problematic. Here's why, and this is in the Tish trial. Specifically, Cohen, during the Tish trial, this is a federal judge writing, repeatedly and unambiguously testified at the state court trial that he was not guilty of tax evasion, that he had lied under oath to Judge Pauley, and when he pleaded guilty to those crimes. That's this case. This judge, right? He's picking this up. He says, what? Wait a minute. You were in Tish's courtroom with Judge Engeron, and Judge Engeron, in his opinion, said that he trusted Michael Cohen. He said, Michael Cohen is credible. He went through a whole stupid filing, several paragraphs, pages, and we read through it. So he says the DOJ is telling the court now that he lied. Here is the testimony. This is a federal judge. To cite just a few examples, here's the judge. Question to Michael Cohen on the stand. Hey, Michael, did you lie to Judge Pauley when you said that you were guilty of the counts that you said under oath that you were guilty of? Did you lie to Judge Pauley? Yes, says Michael Cohen. And we covered that. Whoa, what? You lied to a federal judge in your guilty plea? That's not good. And you just admitted that under oath in your trial with Tish? And I think this was Alina Habba who was doing this cross. He says, yes, I did. Footnote 4. Here it is. Transcript refers to the transcript, which you can find in these court filings. That's a pretty big deal. So the judge, like, this is not Judge Pauley anymore, rest in peace, but the other judge is saying, oh, so okay, in this case number, this one right here, you lied. Yes. Here's another example from the judge. Okay, but you earlier testified that you said you didn't evade taxes. Isn't that right? You said, I didn't evade taxes. I did say that. Right. So you lied when you said that you evaded taxes to a judge under oath. Is that correct? Michael Cohen. Yes, that's correct. I lied to a judge. This was Tish's star witness. Okay. He was on the stand. It all emanated from him. Question for Michael Cohen. And in response to those questions from Judge Pauley, who's in this case, you lied to him. True? that is true. And again, remember, I explained that the judge will go through a whole list of questions. The judge isn't like, hey, Michael Cohen, good to see you. Do you take this plea deal? Yeah, all right, cool. See you later, right? It's a long, drawn out process. They hold up the doc. Is this your signature? Do you see this? They go paragraph by paragraph by paragraph. Anybody promise you anything not contained in this document? If there's any hesitation, the lawyer paused the whole thing, right? The Hunter Biden plea deal went off the rails because of this process. He's like, I was promised stuff that was outside, and he didn't take the deal, to his idiocy. You know, he really blew that one, but whatever. But so here, the questions are, you know, you're under oath, you're getting a benefit for what you're saying, and he lied to the judge. So, Sir Cohen, you lied at the time. You lied more than once in federal court, correct? Correct. When the stakes affected you personally, right? You lied, correct. And you misled a federal judge. Is that right? Yes. And he's going to be the star witness for Alvin Bragg. He was the star witness for Letitia James. That has resulted in $500 million that Trump has to come out with on bond. The judge read the transcripts and said this guy is a flat out liar. Either lied to the judge about committing those crimes or lied in court or lying everywhere. The judge continues, says, this testimony is more troubling than the statements than Cohen had previously made in his book on television. Okay, these are statements that the court had specifically cited in denying Cohen's third motion for early termination, right? So in other words, we denied it the third time for the television statements and his book. This is way worse. Now, because it was given under oath, this is the judge writing, it gives rise to two possibilities here. One, Cohen committed a new crime of perjury when he pleaded guilty before Judge Pauley. Either he's committed a crime there, or two, Cohen committed perjury in his October 23 testimony with Tish. Either one. You can't have it both ways. He testified October 2023, and there's either perjury in one of the two. So which one? So he should be charged with a new crime immediately for this. Okay. Alvin Bragg is going to call him as a witness in his criminal prosecution of Trump, even though a new crime may have been committed in New York in that courtroom of perjury. And if not, then there was a crime committed in Judge Pauley's courtroom for perjury. Either way, it is perverse to cite the testimony, as Schwartz did, as evidence of Cohen's commitment to upholding the law, right? He lied to a federal judge. And either way, it would undermine rather than serve the purposes of sentencing incorporated by reference, including deterrence or rehabilitation or proportionality, to terminate, to even think about terminating his supervised release before its natural expiration in November of this year. At minimum, Cohen's ongoing and escalating efforts to walk away from his prior acceptance of responsibility for his crimes are manifest evidence of the ongoing need for specific deterrence. Now, to be clear, this court does not rely in any way on the citation to the non-existent cases as a basis for denying the motion. Now, among other things, as discussed below, the court agrees that the fault there was with the lawyer, not with Cohen. So we're not penalizing Cohen for the lawyer's submission, but we're penalizing Cohen for his lying. In her reply brief on Cohen's behalf, Perry, Cohen's other lawyer, right now he's not working with Schwartz, Perry tries valiantly to paint his testimony in a more positive light, right? She says, no, he didn't commit perjury, of course not. She contends that the government, which emphasized Cohen's testimony in its opposition, mischaracterizes and selectively quotes from his testimony. She insists that Cohen's testimony, she says, actually reflects something very different than what the government argues, which was an attempt to articulate his belief that such conduct should not have been the basis for a criminal prosecution, right? Not that I'm not guilty of the crime, it's that the crime, that should not be a crime. But these efforts turn a sow's ear into a silk purse. What the heck kind of idiom is that? But these efforts to turn a sow's ear into a silk purse fall flat. That's a new one on me, my friends. Cohen's testimony was not, as Perry contends, a clumsy or poorly worded attempt to argue that, while he committed the crimes that he pleaded guilty to, that the government abused its prosecutorial discretion in charging those crimes. To the contrary, right, he's not complaining that he's not, like, they were unlawful prosecutions. He's saying, I didn't do the crime. The law was valid, but I didn't commit the crime. Not that the law is invalid. To the contrary, he unambiguously testified in Letitia's trial that he did not commit tax evasion and that he lied. He admitted that he lied to Judge Pauley when he had said that. Moreover, when given multiple opportunities to retreat or to clarify that testimony later, Cohen stuck to his guns, perhaps recognizing that the transcript belies her zealous efforts at a spin. This is the judge, like, this is like this Perry person. Perry falls back onto the alternative argument. Perry says that Cohen's 23 testimony, if true, would simply mean that Cohen, like countless other defendants before him, felt compelled to agree to a plea deal under severe pressure, which maybe that's true. Cohen is free to make that claim publicly, but he can't do that and simultaneously ask this court to shorten his sentence when he has demonstrated an exceptional level of remorse. Like, okay, don't tell us that he's remorseful if he's clearly not remorseful. Like, come up with a different basis, or don't ask us to terminate this. Now, in short, they say there was a substantial change in circumstances between Cohen's third application and this one, his fourth, but that change was his testimony in Tish's trial, which was either perjurious, he lied, or it confirms that he committed perjury before this court. So he lied in New York, in Tish's case, or in this courtroom. Either one makes plain that Cohen should be required to serve out the remainder of his supervised release. And so accordingly, the motion for termination is denied. And here's another section. The question, of course, is about those fake cases. Should there be sanctions for that lawyer? I don't know. Let's see what the judge says. In its order to show cause, we issued 3 different grounds that we can sanction you on. He says there's no doubt that sanctions can be imposed on at least some of the grounds for these citations to other cases. The judge actually cites some real cases here. Significantly, however, to impose sanctions, we got to find some bad faith. And so we got to find that there was some bad faith here. And here, in light of these standards, we're compelled to conclude that sanctions may not be imposed on Schwartz. His citation is certainly embarrassing, and it's certainly negligent, and he should feel bad. It might even be grossly negligent, but the court cannot find that it was done with bad faith. Schwartz understandably believed the cases had come from someone competent. Everyone knows Cohen's an idiot, so you can't fault the guy. As Schwartz himself concedes, it was plainly his responsibility, but he says he thought he had accuracy in Perry's reputation. And the court says he seems like he was honest, it was an unfortunate mistake, and he fell on the sword, right? Which is, you get a benefit when you do that. Perry, in responding to this, even a quick read of the citation should have raised an eyebrow. The citations were bizarre. They were all from the same court, like back-to-back years. You're like, seriously? There's like 3 cases exactly on point for the very issue that I need that all happened last year? That's incredible. Out of the Court of Appeals? Wow. It's like, that's not how this works. That may be so, but it still was extreme carelessness, but not intentional bad faith. So there's no basis to impose sanctions on Cohen for this citation problem. The court's order to show cause did not alert Cohen to the possibility of sanctions, but still it wouldn't be warranted. Cohen is a party to this case, and as a disbarred attorney, is not an officer of the court anymore. So it's surprising. Now he says he's still an idiot. He's entitled to rely on his counsel, but given the amount of press and attention that Google Bard and other generative AI tools have received, it's pretty surprising that Cohen believed it to be like a supercharged search engine that produces magical case citations for free. You know how much Westlaw costs? Do you know how much LexisNexis costs? It's very expensive. So if Google Bard just, enveloped all of those different search tools, he's a lawyer. He knows this. The magical search engine that just spits out exactly what you need. Incredible. Judge doesn't believe it, right? But the court has no basis to question his representation that he believed them to be real. I mean, he's an idiot. What can you say? What can you do? Indeed, it would have been downright irrational for him to provide fake cases for Schwartz knowing they're fake, given the probability that Schwartz would discover him or that the government would discover them. So we don't think that Cohen was also that stupid, but he was stupid. So, all right. In sum, as embarrassing as this unfortunate episode is for Schwartz, and it's like memorialized in this document for all eternity, if not Cohen, the record does not support the imposition of sanctions, even against the lawyer. And so for the foregoing reasons, the court denies Cohen's latest motion for early termination and declines sanctions. And so the court's directed, so ordered. Signed by Judge Jesse Furman, United States District Judge. So you see there, this is a bona fide ruling from a judge that in a normal country where we had prosecutors that didn't like people lying to courts, they would take action on this, charge him with perjury, because it's very clear. He either lied to the court in Letitia's case, or he lied to the federal judge when he took his plea deal. And Tish made her entire case based off this guy. Now, we got reaction. Cohen is commenting, this guy is right now a clear liar according to a federal judge and according to his convictions. He's going to be the star witness in the Alvin Bragg prosecution, in addition to Tish's prosecution. And so listen to this little bit of an exchange about this guy and what he's trying to do to sell his books.
Michael, while Trump isn't fully planning to use a advice of counsel defense, he's filed some notice that says that he still intends to make the case that he lacked the required criminal intent to commit the charged crimes against him because people like you were handling the hush money payments. What do you make of Trump trying to thread this needle, hoping to keep his attorney-client privilege sacred sacred and intact while still trying to punt all the blame on you.
Yeah, well, of course, that's exactly what Donald does. It's deflect, deflect, deflect. And as you said, delay for another day. You know, Katie, I don't...
Now watch him deflect right now, okay? She asks him a pretty pointed question about attorney-client privilege and reliance of advice of counsel. And watch him say Trump deflects, and he just deflects right now. Watch.
I don't want to get into too much of the case itself, the Manhattan DA's case, because I don't think it's fair to them. Let me just say that there is something called the crime-fraud exception rule, which, of course, would negate this altogether. But again, I don't really want to get into too much of the case. One of the things that we do know is that there are documents that Donald and his legal team were not given. And I stand with Ms. McCord, who was just on your show a few moments ago. Everyone, including Donald Trump, is entitled to the full set of discovery in order to defend themselves. Now, of course, except for Michael Cohen, because one of the things I talk about in my book, Revenge, specifically it's page 235, is getting documents from the government, especially when the government knows that they've done something wrong. And I'm not talking about the Manhattan DA here. I'm talking about the Southern District of New York. We have been asking under FOIA for documents, both from the Southern District of New York and from Department of Justice for 3 years. Now, it's not just Michael Cohen asking for it, and I do have Mark Zaid in one case, I have Jeff Levine in another case, but we have been asking them for 3 years. You know who else asked Katie for the documentation so that they could look into it to investigate the weaponization of the Justice Department by Donald J. Trump, Bill Barr, and others? Hakeem Jeffries.
All right, so I don't even know what he's talking about there. So we're talking about he's supposed to be a witness in this upcoming Trump trial. In his book, that was adverse to his plea deal, and a federal judge just called him a liar, and now he's talking about, I don't even know what he's talking about. So we'll see where this goes, but how can you be a prosecutor like Bragg and put a liar on the stand, someone who's already been convicted of perjury, and someone who may have committed perjury literally at the last trial, like literally at the very last trial he testified in, right next door in Tish's courtroom with anger on, he lied, and he's going to be the key witness for Alvin Bragg yet again, and he's out there trying to sell his lying book. So this is Alina Habba. She's responding to what's happening in New York, obviously calling it a total and complete injustice, because it is. Let's hear from Trump attorney Alina Habba.
Those court deciding, the appellate division deciding that perhaps they're going to make some modifications to this judgment.
Right. Well, our argument in front of the appellate division is that forcing him to sell prized properties such as Trump Tower, iconic properties like 40 Wall Street, to pursue his appeal is manifest injustice, and it deprives him of that due process that we are all entitled to. So imagine you can't reverse selling off Trump Tower on a fire sale at a discounted price. We can't fix that if we win on an appeal. So it's complete injustice. And only a handful of sureties, as we stated, are approved by the United States Department of Treasury to even underwrite bonds of this size. So of those, even those very limited handful amounts, they're limited to policies with even single bonds up to maybe 100 million. None of them accept hard assets. They require cash or cash equivalents, such as marketable securities. The ask of Judge Engoron is completely ridiculous. He knew that, or if he didn't know that, then he should have educated himself on it. But it is intentionally to interfere in the election, to hurt President Trump, to try and ruin his company and ruin a person and a family whose private company, not public company, has made the skyline of New York changed forever and made so many jobs, created jobs, taxes to New York. It's a disgrace, Martha. So we're waiting on those reasons that we've stated in our appeal and many more, but that's just a summary of what we're waiting on the appellate division to do.
Alina, do you have any sense of whether or not the appellate division is sympathetic to this argument and what their time frame might be?
I can't imagine they are.
Respond to it, because 5 days is not that much time.
We got Monday.
No, it's not that much time, and we pressed the fact that this is urgent. And I will say the appellate division has been great in looking at these things in a timely manner. There were days where we've taken things to the appellate division and waited to be heard, and they heard us. They definitely, we can tell, have listened to our arguments fairly. You know, don't forget this case.
And real quick, they are now saying that they are about to seize this property, Seven Springs. This is some of the latest rumors here that Tish has filed notices with the courts in Seven Springs saying that she may close on that property. And I was wondering if that was part of the original litigation in the first place, right? Why isn't she going after? She said she had her eyes on Trump Tower, and I thought that was part of the actual litigation. But is she going after properties that are not a part of the litigation? That'd be curious.
The judge had a trial where he disregarded the appellate division that shortened the statute of limitations here and said that this case was limited and that he just disregarded it. So that in itself should, to me, this judge put his nose up to the appellate division, disregarded the rule of law, disregarded the higher court. And in that alone, they should take that into account, let alone the other injustices that we saw for those 11 weeks in trial.
Right on. Alina Habba explaining what's going on, that they're having a difficult time getting a bond because it's an insane bond. And we have been wondering if Trump is just going to say, all right, let's call your bluff. Go take a building. Let's see how that looks to America. Go put a big fat padlock on Trump Tower and tell everybody this is our building now, and see what people say about that all throughout the country. Vivek, who is not going to be the vice president apparently, is saying that Tish needs to be disbarred. And I think he's absolutely right about this. And hopefully more people start calling for, the licensing agencies to take a look at these prosecutors because they are violating their ethical obligations. Here's Vivek.
The Letitia James crusade against Donald Trump is disgusting and is a threat to every American. When you have prosecutors who are elected to office on a promise of going after one particular individual as she campaigned on, then go on to keep a campaign promise using the legal system to do it, it's unjust. And this particular case reveals how ugly that is. In this case, you're talking about a crime for which there was literally no identifiable victim. The people who did business with Donald Trump weren't individual consumers. They were sophisticated financial institutions who made money from their dealings. And yet Letitia James is using a consumer protection statute to literally make up numbers and say, hey, you have hundreds of millions of dollars in penalties that you owe. You have bond to post by a particular date of an unreasonable magnitude that even no billionaire is regularly able to meet. And to say, if you don't do it, I'm going to start seizing your property. It's disgusting, and it is a threat to not only private property, but threat to the justice system and to the rights of every American. But the good news is there is an argument to push back against this in short order, and that's the Eighth Amendment. The Eighth Amendment prevents the imposition of excessive bail or excessive fines. And if there's ever an example that meets that to a T, it's the bond that's been demanded of Donald Trump in this disgusting New York Letitia James-led prosecution. This is an opportunity for the Supreme Court to step in and say, no, we're not going to stand for this kind of lawfare. Whether it's against Donald Trump or a Democrat, it's wrong. We don't want to empower prosecutors to be able to use bond and bail or bonds as a way of effectively achieving a goal that they couldn't achieve through the front door, which is bankrupting an opponent, even stopping them from being able to appeal those decisions. That's un-American.
Costing them millions.
It needs to end now, not just the protection of Donald Trump, but for the protection of every American. And in this disaster, I at least see a silver lining of some hope that that's exactly what we'll get from the Supreme Court. It's not just the current justices, not even the conservative ones, that would necessarily agree with this principle. Ruth Bader Ginsburg was a staunch defender of this part of the Eighth Amendment as well. She's no longer with us, but the other justices are. And I hope this can be another 9-0 rebuke of the kind of lawfare that we're seeing against Donald Trump and indirectly against every American in this country today. And I think it could be the most important Eighth Amendment case of the 21st century. I hope they bring it, and I hope they succeed.
Trump's making a lot of history, a lot of case law made around this man because they're so petrified that he might win again, that they're doing everything they can to stop him, including perverting and twisting our legal system beyond even recognition. Here was Trump. He was out earlier this week on the campaign trail. I think he was voting for himself in the primaries. Well done. And here was what he was saying when he was asked a couple questions out by the media.
Let's leave you for a second, Senator. Donald Trump, after voting in Florida for the Florida primary, is speaking to reporters right now in Palm Beach. Let's listen.
But that's the way it is. They treated him very, very badly.
Will Paul Manafort come back to your campaign, sir?
I don't know anything about it, but he was another person that was treated badly, and he was a patriot. But we'll see what happens with that. We have a lot of people involved in the campaign. They've done a tremendous job, and based on the polls, we're doing extremely well.
Mrs. Trump, are you going to return to the campaign trail with your husband?
Stay tuned. Stay tuned.
Stay tuned. Are you confident that you can pay $464 million?
I built a great company, one of the greatest companies anywhere in the country, especially when it comes to real estate. Have some of the greatest assets in the world. And this is a rigged trial. This was a rigged trial by a crooked judge and a crooked attorney general.
With a lying witness.
We're fighting it out with them. We have a lot of cash and we have a great company, but they want to take it away, or at least take the cash element away. Billions of dollars in value, billions of dollars in properties, but they'd like to take the cash away so I can't use it on the campaign. And this is just a corrupt group of people. It's election interference, and we'll see how the courts rule on it. And I'll be guided by the courts.
All right, that's the president and the first lady out there responding to the crooked and rigged process that's happening all over New York. And now a federal judge in Michael Cohen's case confirms he lied again. He either lied in court or he lied in court. He either lied when he took his guilty plea or he lied in Tish James's courtroom. And Judge Engeron said that he believed that. So we have a pretty big conflict here where liars are allowed to take the stand and bring in key evidence against certain individuals individuals who are on a politically disfavored part of the American conversation. And so we're going to be here continuing to cover this case and the other cases. Of course, this guy is going to be the center, the hub of the Bragg prosecution if that gets back on track. And we're going to see what these appeals look like now that it's confirmed by a federal judge he's a perjurer again. We're going to be covering it, my friends. Thank you for joining us as we do. Thank you so much for liking this video, subscribing wherever it is you're watching it. Thanks for inviting a friend or family member to come over and join us when we go live. We got some great links down in the description below. Check out robertgovea.com to see the PDF that we just reviewed and to sign up for our newsletter. We also have watchingthewatchers.locals.com, which is where we have our members only community. We do streams in the morning. We do shows on Saturday. We'd love to see you there and right back here on the next one.